Dear Professor Porat, dear Professor Kalafter, dear guests and colleagues, it's always good to be back at Tel Aviv University. Well, I didn't plan to speak on that, but since Dina mentioned, so yes, indeed, Israel was honored with the prize for closing the gender gap in an event that took place in the European Parliament in association with the Organization of Women in Parliament, and there were representatives there from dozens of countries from all over the world, and it's warm. It warms the heart to see that sometimes we are also awarded and our achievements are appreciated. Although, as you said, we have a lot of work ahead of us also in this area, but it's good to get incentives on the way. Today we are celebrating the International Day of Human Rights, as already mentioned, and we are also celebrating a tremendously important project, the collecting and compiling of laws concerning equality and anti-discrimination from all over the world. And I think it's inspiring to see that at least on the declarative level, a consensus has been reached about equality and the importance of legally protecting it, as demonstrated by the vast number of states that have implemented anti-discrimination legislation. And it's really impressive to see the diversity of legislation in this area, and at the same time the consensus around some core issues. Although we are also aware of the fact that sometimes the normative decision regarding who is equal to whom remains somewhat controversial, and accordingly the implementation of equality legislation is sometimes susceptible to being complicated. But still, having this at least declarative consensus is a very important starting point. The topic I would like to focus on today is the special role of legislatures in promoting equality, as well as their unique contribution to this goal in comparison to other branches of government, including the judiciary. Since we are celebrating here a project that focuses on legislation, not only focuses on equality, but rather focuses on promoting equality through legislation. And therefore, I want to shed light on this institutional aspect of this institutional choice of promoting equality through legislation. Traditionally, and despite the fact that equality legislation is not a new phenomenon, the mission of promoting and protecting equality rights has been associated with the judiciary, or at least more with the judiciary and not with the legislature. The reasons for the centrality of courts in the equality discourse are obvious. Courts tend to be the first and direct address for aggrieved individuals who bring claims against discrimination and insist on enforcing their rights. In addition, as we know, courts tend to be especially sensitive to the importance of protecting minorities who are susceptible to being victimized by discrimination due to majoritarian policies. Therefore, don't worry, I'll soon get back to the legislatures, but I want to address the role of the courts as a matter of comparison. So courts are very much associated with this task of promoting equality. And therefore, it is relatively easy to refer to well-known judicial decisions which promoted equality and have already become part of the public domain. Some of these decisions are famous and well known also for people who are not lawyers or jurists at all, but they became part of, I would say, the general culture. To mention, just as a matter of example, the very famous decision of the United States Supreme Court, Brown v. Board of Education, which recognized that segregation in schools is discriminatory and hence unconstitutional. And of course, we have examples of leading cases that celebrate the equality principle also in the Israeli context. And here I can also mention a few of the most well-known ones in the public domain, such as the Alice Miller case, which opened the gates of the IDF pilots course to women, the Danilovitz case, which intervened in the discrimination of employees based on their sexual orientation, and many more other landmark cases. These decisions not only enforced the right to equality, but rather also contextualized it and influenced public perceptions, which is not less important. However, and despite the importance of these judicial decisions, the important role of courts in promoting equality and fighting discrimination should not blind us to the following. First, the responsibility for promoting equality should be shared by all branches of government, including the legislature and the executive. Second, and even more importantly, not only should the responsibility be carried also by the legislature and the executive, in fact, it should be carried first and foremost by them. This is not to say that courts do not play a pivotal role, or that they should not be hesitant, or that they should be hesitant in promoting equality. Not at all. It is, however, important to emphasize that they should not be abandoned to shoulder the burden of the battle against discrimination alone. The legislature is, in fact, the most important actor in the arena of equality law. A legislative reform introducing the duty to treat all people equally in domains which used to be free from this duty can bring about a change that can supersede years of litigation. In the United States, the civil rights legislation of the 1960s played a major role in promoting the equality revolution of the time. In Israel, there are several major laws on equality which have reshaped the areas of life dominated by them. This list includes, just to mention a few famous examples, the Equal Opportunities in Employment Law, the Anti-Discrimination in Public Places Law from 2000, and even the Prevention of Sexual Harassment Law that, in essence, is also a good example of equality legislation, and of course there are many more. Statutes, laws, have several other clear advantages in this area when we compare them to judicial decisions, for example. They can create new judicial procedures that make enforcement easier, such as class actions, for example. Class actions cannot be, this process cannot be imagined by court. It can be introduced through legislation. They can also create new paradigms for promoting equality beyond the classical equality discourse, such as affirmative action legislation. They can make normative choices regarding the area of law used to promote equality. For example, they can extend the duty to avoid discrimination from the public sphere to private and semi-private settings, such as, and I mention here examples that were famous for being discriminatory in the past, clubs and facilities which serve the public and that we know that were tainted with discrimination in the past. In addition, and I still refer to the legislatures can decide whether discrimination should be regarded only a private law wrong or also a criminal offense. This is another very important choice that can be made by legislatures and not by courts. Last but not least, legislation has an especially important role in shaping public perceptions and inspiring education. Alongside the legislature, the executive branch must also play a major role in promoting equality. The government is in charge of the important role of allocating resources and therefore carries the responsibility of allocating them equally. In addition, government agencies can decide to adopt affirmative action programs even beyond what is mandated by legislation. And of course, the government is in charge of the important role of enforcing equality norms. The courts are not completely dependent on legislative and executive decisions to promote equality. Their duty to do so derives from the fundamental principles of the legal system, formal constitutions in other countries, and in the case of Israel, the Declaration of Independence and the Basic Laws. However, when the legislature and the executive fulfill their role in promoting equality, the courts are able to act with the additional legitimacy deriving from this commitment, as well as with the ability to rely on statutory provisions on remedies, which make it possible for them to be more effective. I would like to return to where I began. The current initiative dedicated to equality legislation, This project is not about simply adopting one more strategy in the hard-fought battle against discrimination. Rather, it focuses on the most effective legal measure for doing so, although not a legal measure that can stand alone, legislation.
We continue with two more excerpts.
Constantine the philosopher lived in the 9th century, a Byzantine Greek scholar. And he wrote, "Does not God's rain fall upon all equally? And does not the sun shine also upon all? And do we not all breathe air in the same way? Are you not ashamed to mention only 3 tongues and to command all other nations and tribes to the blind and deaf? Tell me, do you render God powerless, that he is incapable of granting this, or envious that he does not desire this? We know of numerous people who possess writing and render glory unto God, each in its own language." Justice Michael Cheshin of the Supreme Court, 1998, described the principle of equality as the king of principles, the most elevated of principles above all others. So it is in public law, and so it is in each and every aspect of our lives in society. The principle of equality. It infiltrates every plant of the legal garden and constitutes an unseverable part of the general make-up of all the legal rules and everyone. The principle of equality is, in theory and practice, a parent principle, or should we say, a mother principle.